So welcome everybody to the April nonprofit section meeting. Thank you for joining us today. We're going to get started in just a minute. In case you were in a breakout room and missed it a few minutes ago while I was just kind of jabbering on, we're looking for a new nonprofit section chair for next year. Megan's going to send something out about that. So if you are an active member of this section and you're interested in taking a leadership role in that next year, that would also mean that you would become the symposium conference chair for the following year. So for 2024, you'd be the conference chair. And that's the main announcement. If you're interested in helping to plan for this year's symposium, there will be a short symposium planning meeting after the presentation today. So Jeff will speak until about 9:30. We'll take about a 5-minute break and then we'll come back. If you just want some basic information on the symposium and you can't stay for that meeting, the date has been set at the Convention Center. It is December 12th, which is a Tuesday. We will do virtual sessions like we did last time leading up to that date, December 12th in person. And then the other thing to know is that the call for speakers is out right now. So if you're interested in speaking, the call for speakers is on our website. It's posted to LinkedIn and you should have gotten an email about it in the last couple of days. So if you're interested in submitting a session, please refer to the call for speakers. And with that, we'll actually get started today. So I want to introduce Christine Cardinal from Atlantic Union Bank. She's our sponsor. They've been sponsoring these section meetings for quite a long time. And so we're happy to have their support. Thank you, Christine. And today we get the pleasure of doing a brief introduction of our speaker and telling you a little bit about themselves as our supporter.
Great. Thank you, Carrie. Good morning, everyone. I'm Christine Cardinal, and I'm a Senior Vice President in the Nonprofit Banking Group at Atlantic Union Bank. We are pleased to be the sponsor for the nonprofit section meetings. Atlantic Union Bank is the largest regional bank headquartered in Virginia with 20 billion in assets and a presence in the Mid-Atlantic. We are customer focused and offer a full suite of financing and banking services for nonprofit organizations. And now moving on to the intro to our speaker, is my pleasure today to introduce Jeff Tenenbaum from Tenenbaum Law Group. As managing partner, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. Jeff is one of the nation's leading nonprofit attorneys and also is an accomplished author, lecturer, and commenter on nonprofit legal matters. Jeff is the author of the ASE published book, Association Tax Compliance Guide, as well as the award-winning book, Quarantine Cocktails, and currently serves as chair of the American Bar Association's Trade and Professional Associations Subcommittee and on the ASE Legal Advisory Council and Public Policy Committee. And now, without further ado, I will turn this over to Jeff, who will get started. Take it away, Jeff.
Thank you, Christine. Good morning, everyone. Nice to be here. It's been a while since I've done one of these, but it's nice to be back. So today we are going to talk about copyright and trademark issues for nonprofit organizations. I know some of you work at nonprofits in-house. Some of you are outside CPAs and other service providers to nonprofits. But for all of you, it's important for you to understand this really important area of law. It's of all of the several dozen kind of key areas of law that my colleagues and I work on every day, every week, every year for our nonprofit clients. This one is, to me, one of the more interesting ones. I've always really enjoyed copyright and trademark law. It kind of weaves its way into so many things that nonprofits do, yet so many people just don't really understand much about how the law works in this area, including the fact that copyright law and trademark law are two very different and distinct bodies of law. As you'll see this morning, there are some similarities, but there also are notable differences. And I hear from clients all the time, we're rolling out a new logo and brand, and we need to go make sure it's registered with the Copyright Office. Whereas that's really not the right thing. Although, as I'll get into, sometimes with a logo, it may be subject both to copyright protection and trademark protection. So understanding kind of the differences between them, understanding the key legal principles in this area. You don't need to get a law degree in this area, but you do need to understand a lot of the key basics so that you can flag issues. And one of the things that you're going to see, as for those of you who know me well, I really try to focus on kind of practical guidance and takeaways. And there are a lot of good practical things to take away here that if you implement at your nonprofit organization or your clients, can really go a long way toward preventing a lot of big problems down the road. So with that, I'm going to get started. Let me share my screen. Go. Slideshow mode. All right. So what I'm going to do this morning is, first off, it's a pretty dense PowerPoint because there's a lot of information here. I'm sure that Carrie and team and Megan will share it with you afterward, so you can have it as a resource. But there is a lot of material here, and I wanted to make sure I got it all down there for you so that you can be able to reference that going forward. So I'm going to start off by giving you kind of an overview of the law in this area, and then I broke it out into kind of 11 key tips, kind of tips, strategies for and avoiding kind of key pitfalls in this area. And that's how I've structured the presentation today. So let's get going. So IP, intellectual property, is some of your nonprofit's most valuable property. Intellectual property is really broken into 4 categories: copyrights, trademarks, patents, and trade secrets. In the nonprofit world, we generally, or most nonprofits, most of your organizations are dealing just with copyrights and trademarks, which is what I'm going to focus on today. Trademarks include actually 4 different types of marks, although the term trademark is often used generically. Trademark, service marks, certification marks, and collective membership marks. And all of those come into play in certain ways in connection with nonprofit organizations. But what trademarks are essentially brand identifiers. So a trademark is a mark, like a word, a name, a slogan, a logo that identifies the source of a product, whereas a service mark is actually what most association names and nonprofit names and logos are, which is the identifier. The mark is the identifier of the source of a service. And the nonprofit services that are being provided are identified and by your brand identifier, which is your name, your logo, names of programs, things like that. Certification marks are those marks that certify that an individual or a company or a product has met certain standards. And then collective membership marks really aren't used very much, even in the membership association world. They're really not used very often anymore. I kind of break up copyright and trademark when we're analyzing these things into 2 areas. One is protecting and securing your own intellectual property, and the other is avoiding infringing others' intellectual property rights. And we're going to get into both of those today. As I said earlier, there are both similarities and notable differences between copyrights and trademarks, and there can be an overlap between them. So for instance, that example I gave a few minutes ago about a new logo that your nonprofit creates, it's certainly a service mark in that it identifies the source of the services that your nonprofit provides, but it can also be a copyright in that it is an original expression of an idea that's fixed in a tangible medium. And as such, it can be subject to copyright protection as well. And we're going to talk about copyright and trademark rights and how they get created, but then we're also going to talk about how you can secure and maximize those rights through things like registration and notices. But it's important to understand that copyright rights and trademark rights exist even without registration in our country. And that's because we have federal law, we have like federal statutory law in both copyrights and trademarks. We have, in the trademark area, we have state statutes, and then you have state common law rights. Copyright law is only at the federal level, only federal copyright law. It supersedes all states. There are no state copyright rights. There's no common law copyright rights. It's all federal. The Federal Copyright Act kind of supersedes all of that. But with trademarks, it's much different, as we'll get into. And then finally, understand that there are a lot of easy, simple steps that will go a long way in this area, such as effective utilization of copyright assignment or license forms, like with your volunteer speakers and authors. But your frontline staff need to be educated on these issues. That's why sometimes I do kind of staff training sessions for association and nonprofit clients of ours on these issues. I'm going to talk about the role of intellectual property registrations and notices at the federal level, which is what most of you will be dealing with. It's, of course, the Copyright Office for copyright registrations, and then it's the U.S. Patent and Trademark Office for trademark registrations. And then I'll talk about notices and kind of what's allowable, what's not. The role of volunteers is very important. because as I will talk about in copyright law, a work that's created by an employee within the scope of employment is automatically owned by the employer. But for any non-employees, such as volunteers, contractors, consultants, whatever they are creating, they actually own, not you. Even if they're doing it for you, or even if you're paying them for it, they are the ones that own it. So it's really important that you utilize copyright assignment or license forms to get those rights secured by your organization. I'll give you some tips for avoiding infringement, especially copyright infringement. Things like utilizing links instead of copying and pasting, seeking permission, and understanding the fair use doctrine. I will talk about the rights of privacy and publicity and how those are very different and distinguished from copyright rights. And then finally talk about other ways to protect your content besides copyright and trademark laws, such as contract law. So let's get into the 11 copyright and trademark tips for nonprofits. So first off, this is really important and it's super easy to do, costs you nothing, but using copyright and trademark notices is really important. It puts people on notice that your works and your marks are subject to protection, and it goes a long way, and it's just a best practice. So on kind of the front page, homepage of your website, your publications, your journals, your magazines, your newsletters, anything else you're producing, your annual reports, your white papers, put a copyright notice on the front page, usually at the bottom, the little C with a circle around it, and the name of your organization, and then you can or you don't have to say all rights reserved, but that's kind of a best practice. But at least use C with the year of initial publication and the name of your organization. If you even look on the front slide of this presentation, it just says copyright 2023, Tenenbaum Law Group PLLC. Doesn't have the all rights reserved. And you want to use copyright notices in connection with all creative works published by your nonprofit. On the trademark side, you want to use trademark notices in connection with all of your trademark, service marks, and certification marks that are owned and used by your nonprofit. Now, for trademark notices, there's actually two different notices. There's a little TM in superscript, and then there's the R with a circle around it. Federal law says you can only use this, what some people call the circle R, for federally registered trademarks. So even though I said earlier, you can have trademark rights without federal registration, if you want to use the circle R in connection with your logos or whatnot, it has to be a federally registered mark. It's illegal to use it otherwise. But for any non-federally registered mark, you can use and should use the TM in superscript. And while these notices are not mandated or required to have rights, their effective use can significantly enhance your IP rights and eliminate an innocent infringement defense. Be sure to use them prominently, consistently, and in all media. Carrie or someone or Megan, I'm going to defer to you guys to kind of keep an eye on the chat and pose any questions to me as they come along.
Yep, we got you.
Okay, I'm going to keep going. All right, so registration. Let's talk about trademarks first. And I'm also going to throw in here domain names because it's very important as well. But for trademarks, you want to register them domestically. If you're a national organization, you want to register them with the U.S. Patent and Trademark Office. If you're just a state nonprofit and you only operate in one state, you can register with your state trademark office. And then if you're an international organization, this is really important. In most foreign countries, trademark rights are obtained solely through registration. There is no such thing as common law trademark rights in other countries. And it's a first to file scheme in most other countries. And so if you're going to be operating in a foreign country, for more than just a brief duration, you want to find local counsel in that country and register your marks in those countries. You should be registering your name and important logos, as well as slogans, as well as certification marks with the U.S. Patent and Trademark Office. And again, while registration is not required in order to obtain and maintain trademark rights in the U.S., because common law rights, which are basically rights that you get from using your mark. So, and the longer you use your mark, the stronger your common law rights get. and your common law rights can coexist along with the rights that come from that get enhanced by federal registration. But it's just simply a best practice, and for any national organization, while trademark registration is not the least expensive thing in the world, copyright registration is very easy and inexpensive, and you can do it without an attorney. You really can't with trademarks. And even for our 4-lawyer firm, we outsource trademark registration work to a terrific trademark lawyer, because it's really a very specialized thing with a specialized docketing system. And even if you understand a lot about trademark law, which I do, you want to work with a specialist who is kind of tied into the Patent and Trademark Office database and whatnot. And it'll usually cost you, between the attorney's fees and the filing fees, about $2,500 per registration. And then every 5 years, you have to file proof of use to show that you're still using the marks, because trademark rights are all based on usage. You can't just you can file an intent to use application with the U.S. Patent and Trademark Office, but then you have to, within a certain period of time, prove that you're actually using it. And then once the registration is issued, every 5 years, you have to file continued proof of use, or you will lose those federal registration rights. And then, of course, you're going to register your domain names, because you can't use a domain name, your website address, things like that, the domain name and your emails without registration. But federal trademark registration is important, because if you get into a dispute with another party over a domain name, and you think that their domain name is really keying off of the name of your nonprofit organization, if you have a federal registration for your mark, it's going to be very helpful in that domain name dispute process. I talked about foreign registration briefly. There is something called the Madrid Protocol, which is a number of countries are a part of that, and it does allow you to kind of get certain trademark rights in all of those countries by registering under the Madrid Protocol, but it has some real limitations to it. And if you really want to maximize your rights, you should do a country by country registration. And then be sure, of course, if you're developing a new domain that you want to use for a new program, a new product, a new affiliate that you're creating, so anything like that, always be sure to file for domain name registrations for those. And of course, for your new trademarks that you might come up with, intent to use federal trademark registrations are going to be really important. All right, let's move on to copyright. So registration of copyright rights it's very important. It's very easy. It's inexpensive. I think on the next slide, I have a link to the Copyright Office page where you can find the various registration forms for different types of works. I forget what the fee is now. Maybe it's like $65 per registration. And you want to register pretty much all of your content, your website, your publications, journals, magazines, newsletters, and all other important original creative works that are fixed in any tangible medium. That means print, electronic, AV, etc. And so the basic idea of copyright is that you can get protection, and you do get protection for an original expression of an idea. And that's important. I'll come back to that idea, not facts, but original expression of an idea that's fixed in a tangible medium. So it has to be original, has to be, by the way, created by human beings. You can't, have ChatGPT generate a white paper article for you and then go and register it. You could do it, but it would technically it could be challenged because it's not created by human creation. But an original expression of a tangible medium that's fixed. That's original expression of an idea that's fixed in a tangible medium. Now we're going to get into, a nonprofit is an entity, but nonprofits are operated through their employees and their contractors and the volunteers and whatnot. And so we're going to talk about what all that means. But presuming that your nonprofit has those rights secured, then you can register with a Copyright Office, and you should absolutely do that within the first 3 months of initial publication. Because if you register within the first 3 months of initial publication, and then someone else later infringes that copyright, you can pursue them and recover statutory damages and attorney's fees, as opposed to just the actual damages that you can prove. which can be very, very difficult to prove in the nonprofit context. And it's a prerequisite. You can't even bring a suit for copyright infringement unless you have your works registered with a copyright office. But if you've done it either before the infringement occurs or within the first 3 months of initial publication, you can get those statutory damages, which are up to, I think, about $100,000 per infringement, plus recover your attorney's fees. It makes a huge, huge difference. So with being so easy and inexpensive, it's really something that you should be doing on a regular basis. And you really should have, one of your staff tagged with doing that. It is very surprising to me. I literally just had a call with a client yesterday, and we were talking about IP rights, and they do a great job. And they have a several person in-house legal department out in California, really, really sharp general counsel. They are really on top of all of their trademark registrations, but they've never registered a single work with the Copyright Office. And now we're about to enter into a big deal where they're going to be transferring some IP from one of their entities to another entity. And, I'm kind of talking through the various steps of, what the process is going to look like, what sort of agreement do we have to have, things like that. And when I asked about the copyright registration, they've never registered any of their works. You really don't want to be in that situation. Okay, so copyright registration, as I said, simple and expensive. Here's a link where you can go. And it also can be very helpful. We deal with, for our clients, many situations where, someone is infringing our clients' copyright rights, and, on various social media platforms or things like that. And when you go there and there's like a complaint process for things like that. And when you can show that you have a copyright registration for your work, it really goes a long way in helping to get kind of quick reactions and response from social media operators and whatnot. Fourth tip, and this is really important. So, registration and notices are part of protecting and securing your copyright rights. There's some other parts of that too that we'll get into with your non-employees. But once you've secured the copyright rights and trademark rights, again, through maximizing those rights through registration and trademark notices, you want to monitor and police the use of your copyrights and trademarks by others. Use in periodic web searches. There are outside monitoring services you can contract with that aren't very expensive to identify potential infringement of your copyrights and trademarks. And keep in mind too that, unlike, the pre-internet days where it was much harder to infringe someone's copyrights because, you actually had to have a physical copy, say, of a book or an article in order to infringe it. Now so much is available online on kind of non-password protected sites. Just because something is on your site and is available to the public to view without having to, be, say, in a members only section of the website, it doesn't mean it's subject to any less copyright protection. It's still yours. No one else people have the right to link to it, but they don't have the right to copy it and use it without your permission, unless it fits within this very narrow fair use exception, which rarely applies. But bottom line, just because they're not legally able to copy and use and infringe the works that are on your site doesn't mean it doesn't happen. It happens all the time. In fact, one of my nonprofit clients is where we're about to settle the case, but they got sued for copyright infringement. I won't get into the details of it, but lawsuits like this happen. Insurance carrier got involved. Turned out in the end that the plaintiff's allegations were completely groundless. There was no copyright infringement, but the insurance carrier is going to settle it for a modest amount just to make this thing go away. But the point is, if you want to prevent others, that example there was not actual infringement, but actual infringement occurs all the time. And so you want to police this stuff. You want to send cease and desist letters where they are warranted. We draft a ton of cease and desist letters, particularly for trademark infringement, where others are using our client's name and logo, or often like identifying that there's some connection with a nonprofit or endorsement by the nonprofit or affiliation with a nonprofit that doesn't in fact exist, which is a violation of Section 43A of the Federal Lanham Act. So we're often sending cease and desist letters. Stop doing this. You're all probably familiar with a lot of these scam artists that claim to be selling like access to your list of attendees at your conferences, list of exhibitors. They pretend to be the housing bureau for your conference, and they're implying an affiliation, or often stating an affiliation with your nonprofit that does not in fact exist. So regularly engaging or having your attorneys engage in sending cease and desist letters and things like that. And sometimes even more, filing suit or going to arbitration or something might be warranted. But enforcement does not necessarily involve filing a lawsuit. It often doesn't. And it doesn't even necessarily involve utilizing legal counsel. Next slide. So when you are letting others use your intellectual property, your copyrights and your trademarks, we're talking everything from volunteers to members to chapters, affiliates, sponsors, certificates, accreditants, endorsed vendors, all of the above. When you're letting them use your name, your logos, your copyrighted works, and other IP, put the terms and conditions of that license in writing and get the other party to agree to its terms. It's forming a contract. It can be simple. It can be, 2 pages. It can be a click and accept, but you want to always make sure when you're letting others use your copyrights and or your trademarks to make sure you put the terms of that in writing. It might be part of a broader agreement. It might be part of some terms and conditions that people are clicking and accepting, but regardless, you want to put strict limits on how the IP can and cannot be used. What happens is that if those rules are violated, such as, say, a member or a certificate or an endorsed vendor, you want that terms of that license to say, once that relationship no longer exists, they cease to be a member, they cease to be a certificate, they cease to be a chapter, they cease to have the endorsement of your nonprofit, that they agree they can no longer use that. And we deal with issues all the time, like runaway chapters of nonprofits that want to and often do try to continue to use the name and logo of their organization. And if they've been using it for a long time, and if there's no contractual obligation on them to stop using it when they disaffiliate from you, in some cases, they're actually able to continue to use it. And you don't want to be in that situation. It's really important. And when I say, by the way, just as an aside, when I say license, so with copyrights and with trademarks, if you want to let others use those forms of IP, there's 2 ways to do it. One is an assignment, which is a complete transfer of ownership. You might be giving it away, you might be selling it, but it's a complete transfer of ownership. And the other is a license, and that's where the copyright or trademark owner continues to own the work, but they license it to others. And a license can be as broad or as narrow as you want it to be. So for instance, a really broad license would be an unlimited use, perpetual, irrevocable, royalty-free, worldwide license to use, whether it's copyrights or trademarks, can be very broad like that, or it could be much narrower. It could be, an exclusive license. It could have a limited duration on it. It could be revocable. It could be only to be used in a certain part of the country or a certain part of the world. But whatever those limitations are, you want to build them in there. And, sometimes if you get pushback, like I remember when I first started practicing law, I would draft these, like the speaker and author agreements. Let's just say author agreements for, people who are writing articles and whatnot for the nonprofits publications. And I would put in there copyright assignment language, because I figured that's going to maximize my client's rights if they get ownership. Of course, and this is really the beginning of my practicing law, and I got pushback because my clients were saying, well, this looks great, Jeff, but people are pushing back because they don't want to give us ownership. They want to continue to be able to use their works for other purposes. And I realized very quickly that a copyright assignment really wasn't appropriate for volunteer authors, but a license is. And that's what quickly reverted to, and that's what I've used kind of ever since. An assignment, for instance, is more appropriate, like you hire a consultant to write a white paper for you. You're paying them whatever, pick the dollar amount to write something, to create something for you, or you're paying a software developer to create something for you. There you do want to get an assignment of what they create, because that's kind of to be expected. That's the norm, and you're paying them for it. But with a volunteer, a license, frankly, if the license is broad enough, it's going to be more than sufficient for your purposes. And you can also put conditions on it. Like I just wrote an article about artificial intelligence and associations that ASAE is going to be publishing, I think, tomorrow in their daily kind of online newsletter. And it's their copyright form, which I read, of course, before I clicked and accepted. I agreed to it. It's a license. It gives ASAE a broad right to use the article in any way that they want now and in the future. They don't have to pay me royalties, etc. But the one kind of tighter condition on it says that I agree that they will be the first to publish it, that I won't publish it somewhere else before them. And that's fine. That's not unusual. You might even say, your organization is going to be the first, and the author agrees not to publish it anywhere else for 6 months or a year or whatever, maybe except on their own website. You can put all sorts of conditions on there. Be creative if you're getting pushback on things. But regardless, you want to put this in writing, and you need some sort of affirmative consent. Click and accept is fine, but it doesn't have to be an old-fashioned signature, but some sort of affirmative consent by the other party. Just said the first point. And then the last point here is that while oral or implied non-exclusive licenses can exist, exclusive licenses have to be in writing, which for copyright purposes have to be in writing. But while oral implied non-exclusive licenses can exist, they can be difficult to interpret, difficult to enforce, limiting in nature, and otherwise problematic. And so you really don't want to rely on oral or implied agreements when it comes to licensing. Okay. So now what we're talking about here on this point number 6 is avoiding infringing others' IP rights. So you want to ensure that your nonprofit owns or has appropriate permission to use all intellectual property, things like text, graphics, photo, video, trademarks, etc., that are included in your publications, on your website, on your social media pages, things like that. You want to make sure that you either own or have appropriate permission to use. You can always ask for permission. In a lot of cases, because you're a nonprofit organization, other folks will give you permission to use as long as it's not like cutting into their profits or things like that. If we're talking about photos or graphics, if your employees created them or took the photos, your nonprofit automatically owns those. Because I said earlier, when an employee creates something subject to copyright protection within the scope of their employment, the employer automatically owns it. But if it's others, volunteers, paid photographers, videographers, contractors, you need to get that either assigned or licensed from them. And I'll talk about that in a few minutes. But if you don't have the ability to own or get permission from those folks, those non-employees who created them, then go to some of these free sites for photos and graphics that you can use for free without having to get permission. Most copyright problems that I've dealt with over the years arise from the issue of not having sufficient rights or permission. You might have come up with the idea, supervised its creation, paid for it, but that doesn't mean that you own it. You may only have a limited license for a very specific narrow use. So for instance, if someone sends you an article and there's no license agreement and it just says, here's this article for you to publish in the June issue of your nonprofits magazine, and that's all. There's certainly an implied license there for you to publish the article in the June issue of your magazine, but not broader than that. There's nothing broader than that that says that you can later use it in some compilation or later use it in another newsletter or put it on your website or use it as part of materials for a training program, educational conference or program that you're putting together. You don't have the right to do that. There was actually a case involving the New York Times and their freelance reporters that went all the way to the U.S. Supreme Court, where New York Times had a very deficient copyright form that they used with their freelance authors. And the Supreme Court said, there was clearly permission for the Times to publish those articles in the newspaper for whatever that issue was, but not to put it on their online compilation because the license form didn't give the New York Times the right to do that. So the permission was much narrower than the Times wanted to be. Just don't fall into that situation with your organization. Now, I don't think I have a slide detailing the fair use doctrine, but the fair use doctrine is essentially an exception to copyright infringement. It's rooted in the First Amendment. And what it basically, think about it like this. If, say, you're putting on some educational program, and the person who's teaching it, or the trainer, wants to use some snippet of something that's subject to copyright protection, just one paragraph or one page or whatever from a much larger publication, for educational purposes. Basically, so long as you're only using a small portion of the other work, so long as it has some kind of bona fide nonprofit purpose, usually educational, and so long as your use doesn't cut into the profits of the copyright owner, that's probably going to be permissible for fair use purposes. But what a lot of people think is they say, oh, especially C3 organizations, they think, oh, yeah, we're a nonprofit, so fair use, we can use anything as long as it, is in furtherance of our mission and purpose, even the whole article or the whole book or the whole whatever. And that's just not the case. It's just absolutely not the case. Anytime you're going to rely on fair use instead of getting permission or getting, an actual license, or, well, permission is a license, or getting ownership, make sure you consult with legal counsel who has experience in the area. So kind of the example I was just talking about earlier with the New York Times, when you wish that you want to use the work for another project or another medium, you might learn that a separate fee and permission are required. So that example of the volunteer author who gave you an article for one publication of your magazine, but nothing more, and you find, later that you're using it in other forms, and doesn't happen often, but people do come after you for copyright infringement, you're going to end up having to buy them off. And there's just no reason to be in that situation, because as I said really early on, if you do some of this proactive planning, really simple stuff, simple license forms that are not going to be objectionable to people if you do it right, then you're going to solve a lot of these problems down the road. So for copyrights, you want to obtain either an assignment or a work made for hire. So let me explain this for a minute, because you see this all the time. So work made for hire is similar to assignment, because it means there's a transfer of ownership, but it's like assignment plus. It has some enhanced rights that go along with it. But there's only 7 or 8 categories that qualify as a work made for hire. The employer-employee relationship is one of them, but most of the rest typically don't apply in the nonprofit context. So a lot of times what you'll see language in a provision, maybe it's, an agreement with an independent contractor, or an agreement with, someone you're commissioning to write something for you. And it'll say, this is going to be a work made for hire. However, if it doesn't qualify as a work made for hire, then the author or the creator agrees to assign it over to your nonprofit organization. Part of it has to do with the length of how long we're talking about. It's really not a relevant issue, because for copyrights, most of the length of the copyright term is going to be 75 years, which should be more than sufficient for most of you. Whereas a work made for hire can be a longer duration. But regardless, make sure one way or another, or both, that you get, if you can get it, especially if you're paying for it, get a transfer of ownership through an assignment. And then if you can't, and like I said earlier, a lot of times a broad, perpetual, non-exclusive, worldwide, unlimited use, royalty-free license is probably just as good as ownership. Again, so long as you're not concerned about the actual copyright owner using their own work in some competitive way. But for things like articles, photographs, other things like that, a broad license is probably going to be sufficient. But again, if you're paying someone like a photographer or videographer, you want to get an assignment. For copyright or trademark licenses, be sure, like I said, that they're irrevocable to the extent you can get it, perpetual, worldwide, and royalty-free, and I should add unlimited use. Specify whether it's exclusive or non-exclusive, or perhaps exclusive for a certain period of time. Cover all possible current and future uses of the work in all media. Again, if you can get an unlimited use license, that's better. Contain a release to use the author's or speaker's name, photograph, and biographical information. And that's because that's separate and distinct from copyright law. That has to do with the right of privacy, which is a common law right. and people have the right to privacy with respect to their name, their images, and whatnot. And so, if you want to use that, you need to get permission, essentially a release, in order to do that. And that's why, for instance, a lot of nonprofits will have information in their conference registration and meeting registration terms and conditions that says, you release us and give us the right to take your photograph, take your video, and use it without your permission. That's why it's a release of that right of privacy. In some cases, you want to get appropriate representations and warranties. So, for instance, if you're paying a consultant to write some white paper for your organization, you want to get representations and warranties in that agreement that says, I warrant and represent that this is my own work, that I'm the original creator of the work, that it doesn't infringe anyone else's copyrights, that it doesn't defame anyone, it doesn't invade anyone's rights of privacy, things like that. And then, of course, make sure that the license, that there's some sort of affirmative consent that the party agrees to it. So, number 7, for your agreements with independent contractors, you want to maintain written contracts for the development or creation with all of your independent contractors to your nonprofit, such as consultants, photographers, videographers, lobbyists, technology vendors, and others, to ensure that your nonprofit is assigned or at least has sufficiently broad license rights to all IP that's developed or created by the contractor under the agreement. Because as I said before, without such a writing transferring ownership to you, the basic rule in copyright law is that the person who created the work is the one who owns it, regardless of who paid for the work to be created. You don't want to be in a position where you're paying someone for something and you don't have ownership of it, and then all sorts of bad things can happen. As I said before, this rule does not apply to employees, because ownership of work created by employees within the scope of employment automatically vests in the employer as part of the work made for hire doctrine. And so, whether, a lot of nonprofits these days rely on contractors to do various things that maybe in the past were done by employees, because sometimes you can get it more cost efficiently. You don't need 100% of someone's time. You might be able to get a higher level of talent. And all of that's all well and good, but just remember that because those contractors are not employees, that they own whatever they create, even if it's daily work being done for your organization. So you want to have that broad language, copyright language, in your agreement. And then there's a concept in copyright law called joint authorship and joint works. And what that means is you have 2 or more creators of copyrighted material. Happens all the time, right? It could be, so say, a nonprofit ABC is, creating some new educational program, right? Certainly going to be an original expression of an idea fixed in a tangible medium, subject to copyright protection, right? No problem. But who's creating it? Well, let's say you have staff. Let's say you have an outside consultant that you hired, independent contractor, and let's say you have a volunteer committee, 5-person volunteer committee, who's providing input. Well, if all of them are helping to create this copyrightable content, let's break it down. So for the staff, whatever their portion is, that's owned by nonprofit ABC. But the contractor, they own it unless there's good copyright assignment language in the contract with the contractor. Let's presume that there is, or no, let's presume there's not, because the nonprofit has some vague language about the fact that the nonprofit is supposed to own whatever is created, but it doesn't have that magic language that says, I, contractor, assign my copyright rights over to the nonprofit. Basically, it's a deficient, poorly drafted provision. I see them all the time. In that case, the contractor still owns the work. And then the 5 volunteers, they're all making copyrightable contributions through the discussions. They own a portion of it. So in the end, this content gets created, and you actually have 6 different owners. You have the nonprofit from the work of the staff, you have the contractor, 7 different owners, the contractor, and then you have the 5 volunteers. They are all joint authors. And what that means is that every one of them has an independent right to use the work without the permission of the other. They just have to share any profits that they earn off of the work with the other joint authors on a proportional share based on respective contributions. In short, it's a nightmare scenario. You don't want to be in that situation, especially if you have a contractor or even a stubborn volunteer who's going to cause problems for you. I've seen nightmare situations like this that have arisen, especially with contractors who want to get a lot of money for something. This is so easy to do by having these forms in place and these provisions in place in your contracts up front. They can be really simple. We have a ton of copyright license forms for different purposes. Most of them are a page. They can be done electronically with a click and accept. You can solve so many of these problems by taking care of this stuff up front. So moving on to authors and speakers. As I said, obtain a written and sufficiently broad license or assignment. Usually it's going to be a license from all non-employed writers and speakers for your nonprofit, including members and other volunteers. So I've talked a lot about authors. Let's talk about speakers for a minute. I do a lot of speaking, as many of you know, in lots of different forums, and I'm usually asked to sign some sort of a speaker agreement. And we have some really good forum kind of speaker agreements for volunteer speakers if you ever need them. Of course, this is a session on copyright and trademark law. So of course, there's going to be most nonprofits use a speaker agreement form that contains a license, a broad license. It says, for instance, this PowerPoint presentation, I license it to the nonprofit, to use, today, but for in any other form and in any way they want in the future. You want that to be built in there. So you have, if the speaker is giving you a PowerPoint, you want to be able to use that, post it on your website, maybe share it with your members, use it in future programs, use excerpts of it for your magazine. You want to get the right to that. If the speaker is giving you some, articles or other things as handouts or background materials, again, make sure you have the right to do all that. And then you're going to put some other provisions in there. You're going to put a rep and warranty, again, that the speaker represents and warrants that it's his or her own original work, that it doesn't infringe anyone else's work. The speaker agrees they're not going to defame anyone. They're not going to, disclose any confidential information. They're not going to use the presentation as a platform for selling their products or services, other things like that. And then the last kind of, there might be a few smaller things, of course, dates, times, and if there's any fee or honorarium or expense reimbursement, all of that would be in there too. But then the last one is that release, again, due to the common law right of privacy, that you want to give the nonprofit organization the right to say record or take photographs. If I just gave an in-person presentation at the California Society of Association Executives annual meeting in Sonoma. Yes, not a bad place to give a presentation. And they had a photographer going around and taking pictures of me when I was speaking. That's contained in their speaker form that gives them the right to do that. They don't have to come back and get permission later. So again, right of privacy, getting a release, very different from copyright. In copyright, the way the law works is the person who takes the photograph or takes the video is the owner of that work. So again, California Society of Association Executives, I'm sure, has an agreement in place. They better, because they're my client, and I've taught them that. They should have a provision in place in their agreement with the photographer, where the photographer says, I'm getting hired to take these pictures at this conference, and I'm going to give them all to you by a certain date, and I'm going to transfer ownership of them to you. So you want to go through and kind of check all those boxes. You got to think of all of the different players involved and make sure you're securing those rights. That's what we're trying to do, is make sure that all of these rights get kind of housed within your nonprofit, and then you're going to maximize those rights through registration and copyright notices. All right. Home stretch here, 10 minutes. So for the same reason I just talked about with authors and speakers, you really want to get in the habit of doing the same thing with your board members, your officers, and your committee members, and really any other volunteers that are helping I know, like a lot of trade and professional associations that have certification or accreditation programs, have a certification or accreditation council that's constantly reviewing the various standards and other requirements and procedures and due process steps and other things. All of that is copyrightable content. And so you want to make sure you have a form that committee members sign at the beginning of their year of service. Again, can be electronic and whatnot, that says that they agree to assign and will assign all of the copyright and everything that they create over to your organization. And then typically we put some other provisions in those forms, which are different than for authors and speakers. Things like conflict of interest, that they represent a warrant that they don't have any conflicts, and if any arise, they agree to immediately disclose them. Confidentiality provision, that they agree to keep everything confidential. Those are the two main other areas. So often with board forms, boards is more robust because you're going to have typically a more robust conflict of interest disclosure. But with committee members and council members and things like that, having the copyright assignment, the conflict of interest, and the confidentiality included there are very important. Which is what I just said on this slide. Next. So for those of you that have like a membership database or a donor database or other data that's not protectable by copyright law. So if you remember in the very beginning, I talked about the fact that copyright protects original expressions of ideas that are fixed in a tangible medium. But it can't be used to protect facts, just pure facts. And there was a pretty well-known at the time, about 20 plus years ago now, probably 25 years ago, U.S. Supreme Court decision involving Donnelly, which was a company that published, I don't know if they still do, phone books, the old-fashioned phone books that had alphabetized listings of people's names, addresses, and phone numbers. Someone else took the content from one of Donnelly's phone books and used it for some other purpose. Donnelly sued them for copyright infringement. Case went all the way up to the Supreme Court. And the U.S. Supreme Court said, sorry, Donnelly, you're out of luck. This is not subject to copyright. It's not able to be protected by copyright law because it's not a unique expression of an idea. It's just an alphabetized listing of factual information. And so that's not protectable under copyright law. Now, you can protect it otherwise, like through contract. And so if you're going to let others use pure facts of yours that are not subject to copyright protection, but you want to restrict their ability to copy it or sell it or use it for some other purpose, you use a contract to put limitations on their usage. And that is enforceable. Now, Donnelly didn't do that in that situation, and maybe they weren't even able to do it. But just keep that in mind. And then what the court did say is that if Donnelly had kind of arranged all of those facts in a unique, creative manner, not just an alphabetized listing, that perhaps could have been subject to copyright protection, but not the underlying facts. And so that's where this sometimes gets tricky with nonprofits, that the overall organization of something may be protected by copyright law, but the actual pure factual information is likely not going to be. And so if you want to protect that purely factual information, you need to use contract law to be sure that you put restrictions and limitations on that. And then finally, most nonprofits these days, certainly especially trade and professional associations, have like online forums, like a lot of groups use Collaborate, which is a company that kind of white labels online forums, listservs, things like that. Basically, nonprofit sponsored electronic communication vehicles that allow people to communicate with each other. These are common places where we see lots of legal abuses that can give rise to liability, not only for the person who's posting something problematic, but for the nonprofit itself, if it knows or should have known about it and didn't do anything about it. And I deal with everything from copyright infringement, sometimes trademark infringement, defamation for sure, tortious interference with contracts or business opportunities for sure, and definitely antitrust violations, whether it's price fixing, group boycotts, or other things like that, especially in the price fixing area, where people are posting and asking improper questions about prices or fees that are being charged. But all of that aside, obviously this is a discussion today of copyright and trademark law, but the bottom line is, in order to help ensure that these kind of problematic postings don't happen. And by the way, same thing can occur even on your nonprofit sponsored social media pages. In order to make sure that you don't have problematic postings, and to help protect your nonprofit in the event there is a problematic posting, you want to have rules, terms and conditions, terms of use for your online platforms that people have to affirmatively click and accept, that they will abide by as a condition of usage. It's a good idea to have them do it once a year. I mean, ideally, if they just do it in the beginning, that probably is technically sufficient, but as a good reminder and to just strengthen your legal position, I'd recommend trying to get them to click and accept that they'll agree to those terms every year. And those terms include all those things I talked about, like I won't post any material that infringes anyone else's copyrights or trademarks. But also, I won't post any negative comments about any other individuals or companies. I won't post anything discussing prices or fees. I won't encourage participants to not do business with others. I won't use the platform to advertise or market my products or services, things like that. And then if you do have a complaint from someone, and this happens sometimes, that someone posted something that infringes their copyright. So, person A complains to the nonprofit that person B posted something that infringes person A's copyright. There's something called, it's been around since 2000, the Federal Digital Millennium Copyright Act. And basically, if you follow the provisions of this law, you can get protection from contributory copyright infringement if you immediately take down what someone has posted. As soon as you become aware of it, that you immediately take it down. There's also another component to it where you have to have a name, like a contact person on file with the U.S. Copyright Office. But if you do this law helps to give you protection. It's a great practice no matter what, that if you get complaints about a problematic posting, take it down, and then you can look into it further. And if, turns out there's nothing wrong with it, you can put it back up. But anyway, with 2 minutes to spare, that is the end of my presentation. I did want to highlight that at the bottom there, you see our firm's website. We have a wealth of resources on all different nonprofit legal issues, dozens and dozens of articles, PowerPoint presentations, and at least 50 recorded webinars on lots of different topics, including some that I've done with this association in the past. So, and we're always posting new stuff. Just posted a new article about non-compete agreements for nonprofits, and lots of other interesting topics on a wide array of issues. So thank you all for your time and attention this morning. I hope you found it helpful. And if anyone has any questions, feel free to fire away.
Thank you, Jeff. I put this in the chat, so you might not have seen it, but you just gave me such a long to-do list of things that I need to work on. So I appreciate that.
Good.
If you're willing to stay for a second, we'll take questions. Anybody have questions? They all need to absorb it. Well, they've got your email. They can send you questions, right?
Absolutely. Glad to.
Thank you. I don't think we've done a session on this topic that I can recall actually in my entire time here. So thank you. I really appreciate it.
No, I'm glad to do this. Yeah, it's, I speak on lots of different topics, but this one I really enjoy. And this one, a lot of it's not intuitive. A lot of things, I'm sure you learned a lot of things this morning that you just didn't know. Some areas are more intuitive. This is not. So anyway, glad to do it.
Yeah.
Good to see you guys.
Thank you. I appreciate it.